With your leave, Acting Chief Justice, can we ask the Registrar Clerk to call the case, please?
Yes, you may.
Good morning. I am the Clerk Registrar for this hearing. Acting Deputy Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of the member of the Executive Council for the Department of Cooperative Governance and Traditional Affairs, KwaZulu-Natal and Nkandla Local Municipality for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Acting Deputy Chief Justice, am I live?
Yes, you are, Mr. Dixon.
Acting Deputy Chief Justice and other justices, I appear for the applicant, Dixon A.J. SC.
Thank you, Mr. Dixon.
Acting Deputy Chief Justice, am I audible?
Yes, you are, Mr. Matansela.
Yes, and the justices of the court appear together with my learned friend, Sarah Patton Jones, for the respondents.
Thank you, Mr. Matansela. Mr. Dixon.
Thank you, Acting Deputy Chief Justice. Just as an introduction, this is an application for leave to appeal to the Constitutional Court. It emanates from the KwaZulu-Natal High Court. It was decided on the 21st of February 2019 in the MEC's favor. Leave to appeal was granted and it went to the Supreme Court of Appeal, and they upheld the appeal, but they were split on some of the main issues. The cause of action, that is whether it is a legality review or a PADJA review, hence the time limits for the bringing of the application, the issue of delay, and the facts in relation to the cause of action. The SCA Court and the High Court were ad idem on the following two issues. The High Court has jurisdiction, and the effect of the Samwood judgment did not affect enforcement during the period that it was still alive. Lastly, there's the issue of a just and equitable order. This variation between the Supreme Court of Appeal justices and the High Court provides the ground for seeking leave to appeal. Now, I want to deal with three issues first during my protected time, if I can get through them. The first is the cause of action. The case was brought expressly on the basis of a legality review or a declaratory order in terms of section 54A 3 and 8, namely that the appointment was null and void according to the section, and that the MEC made an application for a declaratory order. The written argument of the MEC addresses these issues, and the conclusion is that it is indeed a legality review and the time limit is a reasonable time. Now, turning to the issue of delay, which is one of the hotly argued issues in this case, the principles in Buffalo City versus Asler apply. Buffalo City versus Asler had not been decided at the time that the High Court gave its order, but the High Court applied the cases on which Buffalo City versus Asler was based. So the standard is a reasonable time. This is determined as a value judgment on the facts. If it is unreasonable, then the court has a discretion, nevertheless, to overlook the delay. No condonation application is required. The court can simply consider the delay and apply the two-step Kumalo test. That is, 1, reasonableness is assessed on the explanation for the delay. If there's no proper explanation, the delay will necessarily be unreasonable. And 2, should the delay nevertheless be overlooked on the facts of the case, this is an an exercise of a discretion which is flexible. In Tasima 1, it was referred to by the acting Deputy Chief Justice as a factual, multi-factor, context-sensitive framework. The factors here are the prejudice and the consequences, coupled with a just and equitable remedy to fit this case, and the nature of the impugned decision, i.e. the merits order on the principle of legality. Thirdly, there's the conduct of the applicant. It is submitted that the applicant did act in good faith and with an intent to ensure good governance. Fourthly, the court may, even if the delay is unreasonable, overlook the delay because the court is compelled to declare the conduct unlawful. That is the Kojima principle. Fifthly, if the discretion has been correctly exercised, factually and judicially, then the court should not interfere with the discretion. The High Court found that the delay was reasonable. This is an application of the Notyawa judgment. Now, as far as the delay is concerned, there's a factual component, and this has been the discussion of many of the judgments in this case. The appointments started in January 2017. In the Nkandla case, the appointment was sent to the MEC on the 26th of January 2017. On the 13th of February 2017, particulars were requested, and there was no compliance noted by the MEC. And then there are a number of letters going backwards and forwards. The issues in these documents are that there is an application made to the minister to have the requirements for a municipal manager waived. There's reminder letters. Then the council said that they were waiting for an opinion. It was then followed by an MEC's reminder, and then when that was going nowhere, the application was brought on the 11th of May 2018. Now that is a long delay from the date of the appointment. However, if one considers, as the High Court considered to be a relevant matter, that the MEC has to honor cooperative governance, has to take it step by step because municipalities are autonomous, and she has to give proper respect to their interests before she goes to court. And much of the delay, it is submitted, was caused by the municipality wanting to do further things along the way. What is relevant in this case is that the Supreme Court of Appeal found that there was a dispute of fact, and in my submission, there is no dispute of fact. In the written argument, I've set out the parts in the record where this is dealt with. And if I could just add to that, that Mr. Gilly, who is the man who became the municipal manager and whose qualifications are in question, was being proposed to be an acting municipal manager before this happened. And there was correspondence, which is referred to in on pages 93 to 95 of the record in relation to the same Mr. Dilly's qualifications. And it seems to all intents and purposes that the municipality accepted that he didn't have qualifications. Now, he persists in saying he did, but all I can say is if one looks at the founding affidavit and the replying affidavit and the schedule to the regulations, senior management level means management level associated with persons in a senior management position responsible for supervising staff in middle management positions, responsible for supervising staff in middle management positions, and includes a municipal manager and a manager directly accountable to the municipal manager. Now, as far as B is concerned, the requirement is relevant experience at a senior management level. And with respect to his points, he didn't have that. If one looks at his requirements, when his qualifications, one sees he didn't have that. So despite the fact that he denies it, it's accepted by the municipality that he didn't. And there is a consequence to him throwing in his lot with the municipality in bringing this case. As far as Nkandla is concerned, it's very much the same time scale. 19th of December 2016, there was the appointment, and the application started on the 11th of May 2018. A very similar toing and froing with correspondence. In this case, though, the municipal manager only raised one issue, and that was that the qualifications were not a requirement, which were peremptory. He felt that they were directory, and the High Court disposed, and parts of the judgments in the Supreme Court of Appeal disposed of that. So the point that I would like to start with is that the cause of action is right. The delay has been dealt with. There is no dispute of fact that the two municipal managers did not comply with the qualifications, and that the delay should be regarded as not being unreasonable.
On that note, Mr. Dixon, your 10 minutes protection time has expired.
Yes, thank you, Acting Deputy Chief Justice.
Mr. Dixon.
Yes, Justice Jafta.
Does the declaration of invalidity relating to the section that your client relies on for the cause of action has any impact in determining the validity of that cause of action?
Well, I think the argument from the MEC is that it always regarded, and it had previous cases on which it relied upon, it always regarded this as being a legality review in inverted commas. So it's not really the review of a decision, it's the review of illegal conduct. And because of the first part of the section, which declares unqualified persons to have their contracts regarded as null and void, then one requires a declaratory order in the High Court to have that confirmed. And that is as a result of the illegality of the appointment. I don't know if that answers your question, Justice Jafta.
Maybe I wasn't clear.
Yes.
My focal point is the impact of the decision in sum on this matter. Is it correct that the High Court delivered its judgment on the 21st of February 2019?
That's correct, Justice Jafta, yes.
And is it also correct that the suspension of the declaration of invalidity in sum expired on the 9th of March 2019, just 19 days
Yes.
after the High Court had delivered its judgment?
Yes, it did. That's correct.
So as I understand it, correct me if I'm wrong, as I understand it, the courts below said SAMU has no impact on this matter because the declaration of invalidity was suspended. Now, if the suspension expired on the 9th of March, barely 19 days after the High Court had rendered its judgment. So the period that we're talking about, that the relevant section was in force, is 19 days. Is that correct?
Well, yes, I'm following.
Then if that is so, what you're asking us to do, you're asking us to give your client relief relating only to 19 days. Is it not?
No, with respect, Justice Chapter, what we would do is ask the court to take into consideration that the entire cause of action matured during the period of suspension. So it was the court came and gave a declaratory order on the cause of action which had matured during the 2-year period. And so it's not really just for 3 weeks or whatever it is. It's actually a permanent order because it's declaring what the position was in the past.
Well, now, I think then, okay, the point is you want that declaration of invalidity to be applied from which date? Prospectively. Is that because I'm
Yes.
trying to understand what really are we doing? If we proceed from the premise that as from the 9th of March 2019, you could not rely on Section 54 because it was invalid. It had been declared invalid, and the declaration of invalidity had come into force on the 19th of March.
Justice, I see the issue now.
Yeah.
No, our submission is that you would always be able to bring a case provided the cause of action had matured during the 2-year period. So there are examples.
You can't say after the 9th of March, can you? You can't say the appointment was invalid because it did not comply with the requirements of Section 54, which no longer exist in law. You'll have to go back and say, from the time the appointment happened up to the 9th of March, when the declaration of invalidity came into force, the section was operative and the appointment was therefore unlawful because it failed to comply with the section. Is it
Yes.
that is correct?
Well, Justice Jeffter, the disagreement between us is that if the law was such that it was null and void and contrary to law during that 2-year period, then it doesn't matter what longer time afterwards one asks for a declaratory order that it was unlawful. It remains unlawful. It doesn't get washed away merely because the 2-year period is finished.
No, because now litigation doesn't work that way.
Well, in Gajima, it works that way.
It works this way. When a court declares legislation invalid and period, it keeps quiet, then that declaration of invalidity runs retrospectively.
Yes.
If it's a pre-constitution legislation, it runs back to the date on which the constitution came into operation. If it's a post-constitution legislation, it runs back to the date on which that particular legislation came into operation.
Yes.
So your submission cannot be good there, can it?
No, what I'm doing is relying on the cases that are set out in my written argument, and in particular the all-pay cases, because the all-pay cases dealt with a situation which then became irrelevant, but it didn't affect the legality of those arrangements that were made along the way, because otherwise you would have the service provider in the all-pay case, which was held to have had an illegal contract, having everything that they'd done after the event declared illegal, which is not so.
Can I clarify LP to you? The
Yes.
difference is this. In LP, we said the award of the tender to LP was unlawful for failure to comply with the requirements of Section 217 of the Constitution.
Yes.
Right? And we said a further step, but we suspend the declaration of invalidity
Yes.
for a fixed period of time. The effect of that meant that the invalid contract is saved from invalidity by the suspension of the declaration of invalidity, because then that declaration of invalidity doesn't come into effect. That is why they kept on coming to us to grant an extension.
Yes.
Then the contract was kept alive. Okay? The same principle applied here when the declaration of invalidity was suspended for 24 months. Then the section that your client relies on was kept in force for that period of suspension. But when the period of suspension expires, it means then that the declaration of invalidity comes into operation. So you can't rely on an invalid legislation after the declaration of invalidity has,
Yes.
the suspension has expired.
Yes,
So,
I understand.
That's the difference.
I understand the point, and I understand the difference that you're proposing to me. But Justice Jafter, my answer to that is that the illegality started at the appointment. And if it's illegal at the appointment, it doesn't get lawful just because the section is declared unconstitutional and is suspended for 2 years. It still remains that as at the time of the appointment, it was an illegal act by the municipality.
No.
It doesn't get any better for them.
Yes, I know. Maybe you misunderstood me. I didn't say after 9 March 2019, the appointment became lawful. No. What I was saying is that after 9 March 2019, your client could no longer say the appointment is unlawful because it doesn't comply with Section 54. The reason being that Section 54 has ceased to exist. That's the point, the narrow point that I was making. And therefore, I'm trying to determine when we get to remedy, what is the relevant period? Is it from the date of appointments that are impugned until the 9th of March? Because I don't see on what legal basis can we go beyond the 9th of March, unless I'm missing something.
Well, with respect, I think that you could enforce this illegality or enforce a remedy in respect of the illegality after the 9th of March. Otherwise, you end up with the anomalous situation that before the 9th of March, one can't remove a person who was illegally appointed. Or after the 9th of March, you can't remove him, whereas before the 9th of March, you could remove him. Surely, if something is illegal according to law, it can be enforced at any time in the future, as long as it happened during the existence of the law.
Yes, no, again, I think we're missing each other, but I think we are on the same page.
Yes, yes.
You can pursue the claim, but in relation to the period when the law that you rely on was still in force. You can't say when the law is no longer in force, it is unlawful because it doesn't comply with that law, can you?
Well, that's exactly what I am saying, because I'm afraid we'll have to differ with each other.
Yes, but I accept that. I don't remember now. Maybe you can clarify it for me. I looked at some and I didn't pick up the recording of the order that was granted by the High Court in declaring the section invalid. Remember, in SAMU, we confirmed that declaration of invalidity.
Yes.
So I'm not sure whether the High Court in itself had dealt with the issue of retrospectivity. But in our judgment in SAMU, we say the order will operate prospectively. But in the order itself, we don't deal with the retrospective operation.
Yes, I think that's correct. But that's why I went to some pains to set out the various authorities that deal with how one reads a judgment in relation to suspension and retrospectivity and so on. And my submission is that what the Constitutional Court did on the, I think it was on the 9th of March 2017, is suspend the declaration of invalidity for a period of 24 months to allow the legislature to correct the defect. Well, unfortunately, they didn't, certainly for those parties that would like them to have carried on. But that means that after 24 months, the suspension falls away, the declaration of invalidity comes into effect, but that doesn't affect, just to go back to our earlier discussion, that doesn't affect anything that happened before the declaration came into effect.
Okay.
I can't answer your question about the...
Yes, I understand.
I do recall having taken attention to it at one stage, but I thought that as the Constitutional Court had made its own order of suspension, that I could forget about that.
Okay. And lastly, it seems to me, and correct me if I'm wrong, that the SCA was split on the basis on which the majority supported the order. as I recall, Justice Mulemela and Justice Zlati Poyo based their conclusion, insofar as the delay is concerned,
Yes.
based their conclusion on the fact that this was a Paja review.
I think that that's a fair assumption of a reading of it, because if you find, as they did, that it doesn't matter whether it's PAJA or a legality review, then you've more or less decided that it's 6 months, 180 days, and not a reasonable time, because to find that it's not important to decide whether it's the one or the other really avoids the main topic of discussion, and that is, how long do we have?
Yes, exactly.
Yes.
That's my point. That's the difficulty
Yes.
that I have.
I agree with you. Yes.
Justice Makgoka held that it was a legality review, and therefore
Yes.
the
Yes.
test was whether or not the delay was unreasonable.
Yes, and Ponen,
They said no, it was reasonable because there was an explanation. You had to look at the provisions of Section 41 that says when the dispute is between organs of state, they should try to resolve it before they go to court, and going to court would be the last resort.
yes, that's
Now,
correct.
I'm not quite sure. What do we make of that? How do we come to the conclusion that there was a majority finding relating to delay? Because Justice Makgoka says, on the merits, these guys should not have been appointed.
Yes, but he said the delay was inordinate,
Yeah,
and that the MEC should be ashamed of herself.
Yeah.
Well,
yeah,
that was his finding. So his judgment on that, a single judgment, taken together with Justices Molamela and Poet Lawati, it's 3-2 split on the fact that the reasonableness was excessive. Sorry, the delay was excessive.
it's not. But the problem is that you have the 2 and 1 not agreeing on the basis of, the delay being unreasonable.
Yes.
How do we deal
Well,
with it?
it is complex, because if you accept that Justices Molamela and Poet Lawati were dealing with a PAJA review, which it can't be for all the reasons that I've set out already. Yeah. But if you accept that that's what they thought, then it was clearly after 180 days, there was no application for condemnation, and therefore it was an unreasonable delay. It was actually a critical delay because it fell outside the 180 days. Justice Makgoka, as I understand it, regarded it as a legality review. Therefore, he's judging it on the standard of a reasonable time, and he felt that the delay was excessive.
Yes.
So they are saying different things, and maybe it's not 3-2. Maybe it's 2-2-1.
Yeah. All right. Thank you, Mr. Dixon.
Thank you, Justice Chapter.
Mr. Dixon, my brother Justice
Mablanga, yes.
Yes, my brother Justice Chapter was interested in the intervening 19-day period between the date of the High Court judgment and the terminal point of suspension.
Yes.
In terms of the SAMU judgment. Let us forget for a moment the possible complication that may arise from the fact that our order says nothing about prospectivity, even though the judgment itself does say that the declaration of invalidity is to be prospective. Let's forget that and work on the basis that the declaration was indeed prospective. And an issue that comes to my mind, there may well be a judgment of this court, but I'm not aware off the top of my head, and I want your assistance. My brother, Justice Jafta, touched on the principle of objective constitutional invalidity, where, for example, absent a declaration that the declaration will be prospective, ordinarily in terms of this principle, the statute will be invalid from the date of the coming into effect of the Constitution if the act predates the Constitution, or from the date of the act if the act took effect after the coming into operation of the Constitution. That's not where my interest is. But my interest still relates to the principle of objective invalidity. Now, but the focal point here being, you have a declaration of invalidity, but it is prospective, not retrospective. And then there is a suspension, say for 2 years, as was the case in Samoa. Then the period of suspension comes to an end, and the legislature has not done anything. What happens there? Does the declaration of invalidity take effect from the date of the order, or what happens exactly? I'm asking this because it may be relevance to what we should or should not do in this matter, or what we are able to do and what we are not able to do.
Yes. Well, Justice Madlanga, that is one of the interesting questions about the Samu part of this case. And I've made fairly detailed submissions about it. And I think that despite the fact that Justice Jafta didn't like my examples of the all-pay case, the all-pay case kept alive an invalid contract over 3 or 4 different hearings. And I've set them all out in in 614, paragraph 614. So the examples are there of something that's unlawful and illegal being given legality for a particular period. Now, if I could just take the facts of the case, the loser of the case, Cash Paymaster Services, the service provider, they were allowed to continue their illegal service until the next hearing. They then had that illegal service continued again. But when eventually the date comes where their illegal service stops, you don't go back and look from the beginning and say, well, all of that service that Cash Paymaster Services rendered was illegal. We gave it the nod of a suspension to keep it going, but in fact it's illegal. Now that would be absurd. That would be an illogicality, because this court is allowing them, based on just and equity, allowing them to continue despite the fact that their contract was illegal. In this case, we are dealing with 2 different times of fixing. The first is that if you appoint someone who doesn't have qualifications, that contract is null and void. So that's the time at which it operates. So if you appoint a municipal manager who doesn't have qualifications, it's null and void. But it requires the MEC to go to court to get a declaratory order that it was null and void. And then the court does the the Section 172 operation of deciding whether it's fair and equitable to everybody, and in particular the municipal managers, as to when they fix the date by which time or at which time that person must leave office. Now, we've had a number of situations in this case. The High Court said that they couldn't backdate it. These people had done the service. It would mean them having to pay back their salaries and so on. So it quite fairly said it's going to work from the date of the order. Then, of course, you go and appeal it. That complicates it. The part of the court in the Supreme Court of Appeal, that's Justice Ponnen and Justice Zondi, said that I had agreed with them that there should be no order and it should just run till the end of their contracts. Well, we did have that discussion, but I don't recall ever agreeing to that, because what I said to the Supreme Court of Appeal is that it would mean that they would then be endorsing an illegality. Now we are here on an application for leave to appeal to the Constitutional Court, and we have made submissions that, in fact, we can't ask for it to be retrospective. We would only ask for it to be declared illegal from the date that the court grants judgment. These municipal managers, if I'm correct, have until 1 year after the next election. The next election is in October, so they would have until October 2022 to continue in office. And the submissions I made to the SCA, and I make them again today, is that if someone is unqualified, it doesn't matter whether they've had on-the-job training during the period of illegality, they were still unqualified and they don't fit the purpose of the act as it was then. So I understand the complexity of trying to fix a date and to deal with something with suspensions and retrospectivity. But all I can say in this case is that it would be in order for this court, despite Justice Jafta's questioning of me a moment ago, to say at any time that that act was null and void at the time. We are going to declare it to be null and void. But in fairness to the municipal managers in particular, they should leave their positions on the date of this order, the order that this court grants. That then satisfies the principle. As you can imagine, Justice Mudlanga, it's not these two municipal managers that are really in issue here. This is a problem of province-wide disagreeability. And the MEC has felt that it's important enough to try and get the principle right. It may be asked of this court to accept that this will never happen again. But as I've put up and as my learned friends have put up, there is a bill for Parliament which is on very similar lines. So the same requirement of qualifications is going to be present in the future. So it remains a live issue. It remains a governance issue for the province, and not so much getting rid of these two gentlemen. I don't know if I've answered your question, but
I won't belabor it. All I will say is, like Justice Jafta, I'm not sure that is a good analogy, because in all pay, we never let the ball drop. When it was about to drop, it would be kicked high up again. Again, when about to drop, it would be kicked high up again.
yes.
Here the ball has dropped, and what I'm asking you is, where exactly has it dropped? Has it dropped all the way back to when we granted the SAMU order, or did it drop on the day the period of suspension ended? That's what I was asking you. But as I say, I don't want us to
Yes, no, I'm going to take the same view that I gave to Justice Jafta and hope you accept it.
Yeah. Let me move on to another point. If I'm not mistaken, I think on the facts, it has been said that whatever it is that the MEC did, it was done after the period of, is it 14 days had elapsed?
Yeah, yes.
Whether it's asking for information or doing whatever else the MEC did.
That's correct.
Yes. Now, what are the legal implications of that? That is the effect of acting outside of the 14-day period.
Well, I think the argument that we have always put forward and was accepted by the High Court is that the 14 days doesn't refer necessarily to the bringing of proceedings. And it's a question of an interpretation of sub 8 of 54A. It says that if a person is appointed in contravention, within 14 days, the MEC must, after receiving the information provided for, take appropriate steps to enforce compliance, which may include an application to court. In
That's
other words,
exactly my point. Yes, I'm not even suggesting that it ought to have been proceedings. I'm saying whatever it was, we seem to be in agreement here that it was outside of the 14-day period.
it was outside, yes.
Whatever it might have been, or whatever it was, what are the implications of that?
Well,
nothing done, the 14-day period has elapsed. What does that mean in terms of what may still be done or what may not be done? Or what may never ever be done for that matter?
I understand the point, and I think that my learned friend is going to argue that because nothing was done within the 14 days, then you've lost your chance and you can't ever ask for anything. And I think if you look at the section as a whole, the section as a whole starts off by saying that if you appoint someone contrary to this section, the contract is null and void. And to then interpret sub 8 as giving the MEC 14 days to do something, otherwise she's lost her chance, means that something that is null and void becomes valid just because 14 days has gone past. In this particular case, I don't think it makes much difference, but I do mention it. This all happened over a Christmas holiday and then started early in January or late in January when everybody's offices are back to work. And I think that just shows that the 14 days was a guide and not a cutoff period. And that's, in fact, what I've argued in a number of these cases throughout. It was accepted, it's been accepted by the High Court in Pietermaritzburg and at least three other cases. And that's basically the argument that I have to persist with, that the 14 days doesn't provide a cutoff after which the MEC is non-suited or out of play, because that would negate the entire working of the section. Whereas if you compare it to being null and void and then having to go and get a declaratory order that it is null and void, that shows how the section is supposed to be read. And that doesn't really show that the 14-day period is sacrosanct. My learned friend sent me a copy of the second version of the bill. And that second version of the bill has in it, not the first, not the one I sent up to the Constitutional Court as part of my additional materials. That one doesn't have this new section, but the second version of the bill, which is apparently the portfolio committee's, has the portfolio committee amendments in it. There is a subsection 10, And it says, if the MEC for local government fails to respond to the appointment process and outcome within the timeframes as contemplated in section 7B, or the minister fails to respond as contemplated in subsection 9, the appointment of the senior manager will be deemed to be in compliance with this act. Now, I mention that to show what section 54A didn't have. If it had had something like that, I would be in serious trouble in relation to the 14 days. And perhaps I will be in serious trouble at some time in the future in relation to this, if it gets passed.
If you'll still be in the state attorney's good books.
Yes, I have to stay in their good books. That's quite true. But if and I merely mention this, I can't argue that this is going to be the law. I'm just saying that there are two versions of what is before Parliament, and eventually something will be passed, whether it has this in it or not. But this has its own problems, because the time frame as contemplated in section 7B is that the MEC must within 14 days submit a copy thereof to the minister. It has no reference to 54A8, the time frame in 8. So either the draftsman has missed that, or, and I merely mention these things because they all produce their own results. But the one thing that 54A as suspended didn't have was a consequence for the late bringing of anything, doing of anything. And as a result of that, because there is no consequence, I would ask this court to accept it's merely directory and not peremptory. Sorry, that's a long answer for a very simple question.
Thank you, Mr. Dixon. Thank you.
Thank you,
Mr.
Justice.
Dixon,
Yes.
just on that point, what is the import of 54 capital A9? You've submitted in response to the questions by my brother Madlanga that the section is directory and it is mere guidance. When I look at 54 capital A9, there is no time frame within which the minister must take the steps that are contemplated. And I wondered why, because if everything had to be done within the period of 14 days, it seems to me, my reading, and I may be wrong, is that if then the MEC does not act within that 14 days, it is still open for the minister, even after the 14-day period, to take over the process and actually rescue it, for lack of a better word.
Yes, I accept that, Justice Chiki, and it's I think it's an interesting subsection because it doesn't say within the time period. It just says fails to take appropriate steps referred to in subsection 8. It doesn't say within the time period allowed, but it does give first call on remedy to the MEC and second call to the minister. How the time period fits in there, one doesn't know, but I suppose if the minister comes after 14 days, then no one could complain.
So because I'm thinking the reason I'm following this up, I'm asking, I'm just thinking of a scenario where the MEC then fails to take the appropriate steps within the 14-day period, and then the minister intervenes. Does it then mean that the minister may take as long as it requires to do something? And does it then mean that once the minister has intervened, we no longer look at the 14-day period that is stipulated?
Well, certainly, Justice Chiki, it's quite clear that the minister doesn't have a time period. So the one way of reading it would be, as you've said, that when the MEC doesn't take steps, whether it's in the 14 days or not, I'll leave on one side. But if the MEC is not going to take steps, then the minister may take steps, and he can take as long as he likes, subject, I suppose, to a reasonable time.
And the process would not be invalidated.
No. So if the minister was in fact the applicant here, then this issue wouldn't arise. It does seem to be an anomaly.
It bothered me because then it means that if the MEC had brought this action, then we look at the 14-day period. But if the minister had taken over because the MEC had failed to conform to the 14-day period, then we would have to, because it is the minister who is the litigant, would then have to sort of not take into account the failure to act within that 14-day period.
Yes, I agree with you, Justice Chief.
Well, I'm not saying that's my view. I'm simply, wondering, basically. So I'm not really giving you a gift, but it's something that I thought we could debate and you could come to my assistance.
Well, it certainly does seem like that. That's what it says. And there are obviously quite a few things wrong with the drafting of this section, but I'm trying not to blame someone else for what I have to deal with. It's what we have to deal with, and we've just got to make the best sense of it. And that's why I argued just now that the 14-day period is not supposed to be a cutoff for the MEC, disallowing her to take any action if she doesn't work within 14 days. It's merely directory. In other words, it's an indication that the section requires the MEC to work fast.
Mr. Dixon, the second delay in this matter relates to the actual bringing of the application before the court. We know on the paper that in one instance, the application was brought 15 months after the appointment of the municipal manager, and another one after 18 months. What should we make of that? If we assume that the legality review, would you say that is, if one says the minister or MEC had to cooperate with the municipality before launching the application, would that be a reasonable explanation for the delay?
Just Ms. Lamsha, yes, I understand the issue. And in the one case, I don't want to split hairs about this, but in the one case, it's 13 or 14 months, and the other one is just a month longer. So some sort of assessment of what was going through the MEC's office in taking this time has to be done in this case, obviously. And I've tried my best to set it out in a written argument, and I tried my best a little bit earlier to explain. I have also the High Court and Justice Ponnen and Justice Zondi's assessment to support me, and that is that, and particularly Justice Ponnen says that if this was a municipality trying to delay matters, making promises that they wish to get a legal opinion and not getting it, then this would amount to dishonesty. And I think that that's really what the MEC's argument is all about, that a process was started very, very soon after the appointments. And that process was that you don't comply. Please, can you do something about it? In both cases, they wanted the minister to intervene and waive. And you will recall that in the Nkandla matter, the MEC, in fact, wrote to the minister herself. So she got the ball rolling as far as the ministerial waiver is concerned. But things did tend to develop over time. There was the application for the waiver. Then there was, we want to get an opinion. And what I'm saying is that if there is any delay, it's as much the fault of the municipality as it is the MEC.
In Khumalo, we said where the MEC is involved, she must be she must act responsibly and provide a proper explanation for the delay.
Yes.
Would that be in this particular case? What we have is that, does that meet that requirement for the test
Well,
out in Khumalo?
Justice Mhlanga, I know that it's up to the MEC to explain the delay, and the affidavit of Anusha Reddy, both in the founding affidavit and in reply, seeks to show why it took so long. It sets out in complete form the correspondence that went backwards and forwards. And when a municipality says, please wait, they're getting an opinion, we're getting an opinion, then in this case, they allowed them that extra period to get an opinion until it was clear that they were not going to get an opinion. And then the MEC eventually went to court. So it's a bit of both. It's the MEC's explanation of why they took so long in relation to two municipalities who were not in a hurry to have these people removed. That's the municipal managers removed.
Okay. Thank you.
Mr. Dixon, why isn't the appointment of a municipal manager administrative action?
Well, it takes place by the council, who makes a decision after a process. And well, I suppose the distinction is it executive or is it administrative? And if it's not executive, then it's possible to be part of PADGA. I've always regarded it as being an executive decision, which is not subject to a PADGA review. And I suppose the difference between this case and the normal case where an administrative decision is made is that in this case, you have a section of a different act saying that the appointment is null and void if these requirements are not met. It's null and void. And the MEC can go and get a declaratory order in relation to that. So it's the wording that's used is different to review, because the court is not being asked to review the decision. It's being asked to confirm that the decision was null and void.
Yes, let's first deal with the nature of the decision, Mr. Dixon, before we get to what the court's being asked to do. Or let me ask it differently. Why is it an executive decision then?
Because it's made by the executive in relation to a process. They get handed a candidate and they say, this is the candidate, and the appointment is made by the council as an executive decision.
I can understand that you're saying so, but I want to know why are you saying so?
Well, I think it goes back to the section. I know that I'm answering the back end of your question first, but it seems to me that to fit a decision, which is what PADGA is all about, administrative action, which is a decision, into section 54A doesn't work. It's the wording of section 54A is not consistent with a decision being made that the court is asked to set aside. Either the decision is null and void or it isn't, and the court declares it to be so later. But it's not a review. It's not a PADGA review in the sense of administrative action. That's the definition. And if it's executive, it also falls outside the definition of a decision. But what I'm saying is it falls outside the definition of administrative action by virtue of its substance in section 54A.
If this court was to find or is to find that it's a PADGA review, does the applicant accept that no formal condemnation application was made?
No, and I'm completely out of court.
On another aspect, Mr. Dixon,
Yeah.
the respondents have said that the applicant has not filed a record of decision. And this record might have cleared up with the dispute about the respondent's qualifications, especially Mr. Chili. I know in your opening address to this court, you've said that you've dealt with this in your heads of argument, you've referred us to the passages, but do you say that the applicant has shown that Mr. Chili is sufficiently qualified?
Disqualified.
Yes, it is not sufficiently qualified, yes.
Yes, disqualified. I think that if we're just talking about Mr. Chili, because in Tonjaneni, it's a slightly different set of facts. But if we're dealing with this, and can I just deal with the review record first? The record is not required unless it's a review. This is not a Rule 53 review. It's nothing like it. It's a declaratory order. So from that point of view, the applicant distinguished it from a review and therefore didn't file a record. So that's the first point. The second point is, as far as Mr. Gilly is concerned, the requirements are that he must have, if I can just revert to the requirement, I read the definition of senior management level just now. The years of experience are 5 years, relevant experience at a senior management level. Now, Ms. Reddy said that this is what he said in his affidavit, and these are not senior management level experiences. She distinguishes that from the 2 periods that he was the acting municipal manager, and she excludes that and she puts it on one side, but you don't get to 5 years in any event. And as far as the dispute of fact is concerned and the Plascon-Evans rule, there are 2 submissions that the applicant makes. The first is that it's an incredulous claim having regard to the evidence. And secondly, it was accepted by his 2 fellow litigants, that's the municipality and the council, that he was not qualified. Otherwise, they wouldn't have asked for a waiver from the minister. And that is established by the correspondence which is attached to Ms. Reddy's affidavit. I could just give you the reference in the affidavit. It's 83 to 85. There's a reference to further correspondence. If you recall, Mr. Gilly said you never objected when I was appointed as an acting municipal manager. And Ms. Reddy came back and said in reply, we did. And here is the correspondence to prove it. And the correspondence is at 99, I beg your pardon, 98, 97, onwards to about 105, where there was correspondence between the MEC and Nkandla Municipality in relation to Mr. Gilly's fitness to be an acting municipal manager. And in those letters, they say that to be an acting municipal manager, you have to have the same qualifications as a municipal manager. And Mr. Gilly does not have them. And there is not a single word in relation to that correspondence where the municipality says nobody does have. So they've accepted that he is not qualified. And in fact, at the end of that correspondence, when the MEC was getting serious and writing longer and longer letters, the municipality removed Mr. Gilly and appointed Mr. Nkandla as the acting municipal manager. That's at page 107. This was in 2016, September 2016. So he couldn't have got any further experience from 2016 until his appointment. So what I'm saying as the bottom line of all of this evidence is that on the Plascon-Evans rule, one can't regard this as credible evidence that he is qualified. He said, I'm qualified because I've had this number of days and months in certain positions, and Ms. Reddy comes back and says, but no, those aren't senior management level experiences, so we've got to cut it right down to his 2 periods of being a municipal manager. And with submission, that then deals with the dispute of fact, as it were, in relation to Mr. Gilly.
Thank you, Mr. Dixon.
Thank you, Justice John.
Mr. Dixon, I'd like to take you back to the mootness point, which still bothers me, that my brothers Nkandla and Jafta broached with you.
Yes.
Would I be correct to say that for this question of delay, whether it's a reasonable delay in terms of the legality principle, you'd have to rely on the provisions of Section 54A, not so?
Yes.
Now, as we are gathered here today, 54A doesn't exist anymore. It's a matter of fact and of law, correct?
True. That's true.
Now, when this court heard the matter of Executive Council Western Cape Legislature and also State versus Ntuli, it described the declaration of invalidity as a resolutive condition. In other words, it said in Executive Council matter, paragraph 106, it said, if exercised, the power of declaration of invalidity makes the declaration subject to a resolutive condition. If the matter is rectified, the order of declaration falls away and everything is given validity in terms of the law. If not, that section is then declared invalid and everything done under it is invalidated. That is at paragraph 106 of that judgment. If we apply it to this case, it means that once the date has been reached, I think it's the 9th of March 2019, when the declaration period expired, it means that Section 54A no longer existed. And as Executive Council says, and this court said, everything done under it is invalidated together with the invalidation of the law of the section. So as we sit here today, Section 54A no longer exists. So how could you rely on a section that doesn't exist before this court? Doesn't that render the matter moot? That is my difficulty.
Well, I understand your difficulty, Justice Majid, and I think that if the court decides on what you just told me, then I'm out. But what I would ask you to take account of is that there is a position in Gajima where there was an order granted declaring something to be so. It was temporary, and it eventually fell away. And the court found that if you were in contempt of court during that period, then it nevertheless was contempt of court, even though that order had fallen away and it was something in the past. It was historical. And what I would say in this case is that 54A was historical, but it operated with full force and effect during the suspension period. And because the suspension period then completed, even though it wasn't rectified, it still was law at the time and needed to be obeyed. That's my only way out of that.
Yeah. No, I understand that I understand that contention that you make, and you also make it in the heads. Lastly,
Yes.
just on this aspect, Mr. Madonsela draws an interesting analogy with the JT publishing case. You recall in that case followed about the case at Curtis, a decision of this court, where the same legislation had come under constitutional challenge. But in JT publishing, the applicant challenged various sections of the Publications Act, that's the 74 Act, as being unconstitutional. After the applicant had launched the application in the High Court, and by the time the matter was heard in the Constitutional Court, that act had, however, been repealed, and the Films and Publications Act of '96 was promulgated. And Didcot J said, well, the new statute is there, everything else falls away, and therefore this case is moot. It's of academic interest only. Here it's even worse. There is a new bill, but the statute hasn't been passed, and the previous section has been declared unconstitutional, and the expiry, the declaration of invalidity suspension period has come and gone. Is that a correct analogy to draw? It seems to me to be opposite, or not?
Well, I don't think so, Justin Majid, and I think that far be it for me to think of all sorts of different distinguishable features, but that was a challenge to the publications control legislation which applied during apartheid, and it was to do with Hustler magazine. And at the end of the day, it was moot because the law had been repealed. If, however, there was an ongoing criminal trial in relation to that, then it would not be moot. You'd have to deal with whether a criminal act enacted at the time that a law was in place could still be justiciable. I don't know whether that's a good example, but one obviously has to decide on the facts of each case, how one deals with it. But I accept that under one scenario, it would be moot, but in this case, my submission is that it's not moot because during that period, the law was still there, and it was something happened that was the law declared to be null and void, and that needs to be dealt with.
Yeah, thank you.
Thank you, Justice.
Mr. Dixon?
Yes, Justice Pillay.
It seems that this case presents us with a cornucopia of rules on which to hang our judgment, and many procedural, time-based questions that come before us. And my brother Majid raised the question of mootness, and a few substantive. And the substantive point you raise is the one on legality. And related to that is the principle of corporate governance between various tiers of government. So should we make is there a balancing act that we need to perform between the rules of procedure and the substantive rules, and which should prevail, having regard to the broader constitutional obligations that different arms of government have?
Yes, Justice Pillay, I'm not too sure whether this will answer your question, but it seems to me that the MEC has always relied upon the heart of the case. The heart of the case is that she then, it's now he was intent on creating a climate of good governance in municipalities. And I don't have to tell this court about how that is lacking in South Africa at the moment. So it's a purpose of the Act in a good cause to get local governments to be more efficient and be more qualified. And that's that's with submission, the heart of the case that the MEC is asking this court as the highest court to make some sort of decision on that favors corporate governance, the uplifting of municipalities, the qualification of people who work for municipalities, and so on. When it comes to the personal, you have the two municipal managers who are going to be affected most of all by these rules, and they may be affected by the MEC's delay, and they may be aggrieved by the fact that the MEC took too long to go to court and so on. All of that can be dealt with in a Section 172 order by making something personal to them, which is just and equitable, but still maintaining the principle, which is that I assume it will be accepted that it's a good thing to have efficient local government. And if that approach is taken, then I certainly won't complain that the two, as I said earlier, I won't complain that the two municipal managers stay there for a long time or for a short time, but that's not the issue. The issue is that Section 54A is a good provision, which is intended to do good things, and it's coming back. So it's not just historical. What form it will be in, one doesn't know. And I can't make any submissions about that. We've just given you the two copies of the two different versions. But that to me, I think, is the heart of the case. I don't know whether that's what you were asking me for, but my submission is that is the heart of the case. And you can do justice to the individuals by making a special arrangement for them.
Thank you so much. You've answered my question.
Thank you.
Mr. Dixon, back to
Yes,
the
yes.
back to the mootness question. I just want to understand your submission. You accept that the declaration of invalidity and the failure by the government to cure the defect means that what previously disqualified the two municipal managers no longer applies. And you say that may be so from the 9th of March 2019, but not before that date.
That's correct.
Now, if that is the case, when we then make when we declare them to be disqualified, under which act or provision are we going to make that declaration? Because Section 54A, as it stood then, is no longer valid.
Justice Nkandla, the point that I've made is that at the time they were appointed, they were illegally appointed, and they must take the consequence of that, subject to an order that protects their own personal position. If they had been appointed today, before the new act, between the invalidity coming into force and the new act, then the MEC would not be able to do anything about it. They could be appointed and they would be validly appointed. But the fact is that when they were appointed, they were illegally appointed. And that's all we're asking this court to recognize.
Now, when we do so, if we are with you and we say so, we have to say they were illegally appointed under, in terms of a particular provision. That provision now is no longer there. What should we then say? What should we do?
Well, I think it comes down to something that was illegal at the time and must be recognized as such. This is not like the legalization of cannabis, where a new development has happened, and to keep up with the way people see things. This obviously was a mistake in COGTA. The fact that they didn't operate within 24 months, I mean, they're not before court, so I can't make any submissions about them, but the fact that they didn't do something within the 24 months is a matter of great regret to the provincial authorities. But it wasn't because they no longer wanted that section to be part of the whole array of local government legislation. they just dropped the ball, I think. And it still doesn't, the fact that they dropped the ball doesn't mean that Section 54A had a good motive and it had a proper purpose. And that's what I would ask this court to give recognition to, that something happened during a period when the law was available and it was on the statute books. Something happened which was null and void, and that needs to be rectified.
The last point from my side, Mr. Dixon, relates to the relief that you seek. In the written submissions, you ask that if you are successful, you ask that the High Court order be restored. I noticed that in at the SCA, para 100 of the judgment thereof, it's recorded that counsel for the MEC accepted that the appropriate order would be for the municipal managers to remain in office until the expiry of their current contracts of employment. But before us, you are now saying we should restore the High Court order, which said that they should be removed from their office. What is the basis for the change?
Well, I think that first of all, the concession that was recorded was after I had been put into a corner. And I think perhaps I was compelled I certainly wasn't tortured, but I was compelled to make a submission which was greatly was unwise. But, and I certainly am not making this submission under compulsion at all. But I think that the right answer was that the High Court was right. But as far as this court is concerned, we have a period between the High Court order and this court's order. And it would again be a proper exercise of Section 172, just and equitable decision-making, to say to them, from the date of this judgment, that's the Constitutional Court's judgment, you are out of office. We're now bringing it into force.
And they are left with about, 7 months now? They were appointed 2017 February.
2017 February. I think they've still got a year after the election, so it could be as long as October 2022.
Okay, thank you.
Mr. Dixon, my sister Justice Nkandla had asked you about the explanations given in the two matters.
Yes.
Now, in regard to the explanation for the delay, would you agree that there's more of an explanation in the Mtanjeni matter than in the Nkandla matter?
Justice Tron, I thought they were about the same. The periods are more or less the same, and I thought that what the applicant had done is set out all the correspondence in the back, toing and froing, and what the respective positions of the parties were during that period. So I may be wrong in saying that there was a bit more in the Mtanjeni matter, but certainly as far as the Nkandla matter, Mr. Gilly put up a bigger show about being qualified. That's the distinction there. But as I argued just now, he hasn't gone far enough, and his version is not credible, because what he's saying about his experience doesn't match with what the regulations schedule requires.
Yes, thank you, Mr. Dixon.
Thank you, Justice.
Mr. Dixon, do you have further submissions to make?
I don't, Madam Acting Chief Justice, Acting Deputy Chief Justice. Thank you. I thank you for your time.
Thank you. Mr. Matonzela. Is Mr. Matonzela still with us?
I just have computer problem. Press up. Oh, yeah, I've got it. Thank you, Acting Deputy Chief Justice and the Justices of the Court. I'm so sorry. I was struggling with computers and to get myself back on site. Justices, firstly, we say that the court should not delve into the vexed questions which are raised by the application and the appeal, because the matters which are a subject of that appeal are all matters which have become moot because they relate to a period in time, a 24-month period in time, short-lived period of the Amendment Act, which is now no longer in our statute books. We are literally being asked, or the court is being asked, to cast its eyes back in time 4 years ago, and for a short period thereafter of about 1 year or 2 years, during the interregnum of the Amendment Act, which was struck down, to check whether the legality of the appointment of the municipal managers was good or bad. We say that will serve no purpose now as we sit here, because that statute has already been repealed, and it, as Didcot said in JT Publishing, which is quoted at paragraph 43 of our heads of argument, we are literally looking into the history and not focusing our eyes into the future. What the court will be literally doing is to give opinions. And we submit that it will be a waste of judicial resources for the court to delve into these questions, only if it is to cast its eyes in history. Certainly in relation to the 14-day delay argument which we have raised, that matter is already foreclosed as far as we are concerned, because as the applicants say themselves, there is an attempt now to revise the legislation and reintroduce it. In fact, a bill has been placed before this court. Remarkably, in that regard, and yesterday we tried to circulate the recent version of the bill to the justices, which deals exactly with that topic of the 14-day rule in paragraph 10, which was read by Madam Friend during argument. So the legislature is now poised to address the matter which arises in this case by making clear that the 14-day rule will have the consequences that if nothing is done within the 14 days period, the appointment will be deemed to be a compliant appointment. So there is clarity already from the statute books, if it will be enacted in the manner that it is cast in the latest version of the bill. So there is no longer any need for this court to give any clarification. The legislature has handled the matter for us. So it is not in the interest of justice we submit that the court should now delve on that question and provide any clarification because one has already been given. Or maybe to put it correctly, the legislature is poised to give that clarification in the legislation. So that's our first point. The second point is that leave should not be granted in this case because the basis on which the SCA non-suited the applicant on grounds of undue delay was a fact-specific basis. And this court has always been loath on granting leave to appeal in order to traverse factual issues. We submit that this court should adopt the approach that it adopted in Nochawa, which is a judgment of this court, which is referred to at page 81 or paragraph 81 of our heads of argument, where the court said, well, we're not going to delve into the question of the parja legality dichotomy in order to determine which delay regime should apply. nor are we going to delve into the Buffalo versus City Asla quagmire, whether undue delay should be overlooked even in the absence of an explanation, because those matters were decided on a fact-specific basis. But if the court is minded to delve into the question of Paja legality review, we say that it will be to prejudge the issue, because we know now, as we sit, we know now that the legislature is going to pass, we've been told by our friend, and in the bill, is going to reenact that statute in exactly the same terms, at least in substance as it was. Why should the court decide that issue in the abstract and predetermine an issue that may very well come before the court in the future? We say that it's not in the interest of justice to do so. But if we were to answer the question of whether the decision to appoint a municipal manager by the municipality is an administrative action, or is the legality, it's an exercise of an executive power, we submit that it is an administrative action. And as my learned friend said during the interaction, if that be the case, and you are with us on that characterization, then the application must be dismissed on that basis, because there was never any application in terms of Section 9 of PAJA. That should be the end of the matter. We say it is PAJA because the appointment of a municipal manager is not an exercise of public power in the sense that it is of a public nature. You'll recall that the lineaments of administrative action were detailed, I think, in this court in judgment of Minister of Defense versus Motau, if I recall very well. That dichotomy between what constitutes administrative action, what constitutes executive action. And the court gave us a list of what features of action will make one action to be an administrative action or executive action. But all of that, all those lineaments take us back to the nature of the power being exercised as opposed to the source of the power, something which was said a long time ago in Sidumo. Anyway, that you don't look, in order to characterize a power, you don't look at the actor, you look at the nature of the power. The nature of a public power exercised by the municipality when appointing a manager does not have a public character, in the sense that it has got a wider impact. Like, for instance, a classical executive power of a municipality issuing out rates or determining rates or passing a budget. It is not that kind of power that is being exercised. It is a power that is an administrative one focused on the appointment of an employee for that particular session or that period of time, which is usually 5 years at a time. It is not a power that is easily associated with an executive action, although the municipality or municipal council is an executive body. But the power, the nature of the power they exercise is purely administrative. So we will say, if we are pushed to argue that point on PAJA legality argument, that when we are dealing with appointment of employees or municipal managers in particular, the municipal council or municipality is not wielding a statutory, a constitutional power. It is actually wielding a statutory power. Because in Modau and in the case of Minister of Defense versus Motau, that distinction was made, that if a power being exercised, one that is sourced from the Constitution, that is an indication that it is an executive power. But if it is sourced from a statute, it may very well be an administrative power. So we say on that basis that we are dealing here with an administrative power, and therefore the delay rule that applied is a 180 rule, which required a condemnation or an explanation of the delay, something that was not done here. Thirdly, we say that on the 14-day rule argument, we say that it was incumbent upon the MEC. In fact, it was obligatory for the MEC to act within 14 days. And in this case, it is common cause that she didn't do so. That should be the end of the matter, because the 14-day period that is provided for in the now defined 54A8 was meant to make sure that a decision on the appointment of the municipal manager is executed swiftly or stopped before it takes roots, if it was found to be unlawful. That's why the time limit of 14 days was given in the act itself, so that you don't allow an individual who's being appointed to now reorganize his affairs as a municipal manager, and only 5 months down the line, you have a period where they say, you now must be disgorged for employment because we have found some illegality. The act required the MEC to act swiftly and to make a decision about that individual before that person reorganizes his affairs. It was a protection for the municipal managers who are being employed, given by the legislature, to say, because as it always happens, I think the legislature would have understood that when a person is employed, he has to make arrangements from where he comes from to the position where he's going to assume. And usually a person who is employed will require time to give notice to the previous employer before he takes over the employment. The 14-day period, I submit, was given in order to resolve all outstanding matters during that intervening period, whilst the employee is vacating his old office to assume his old office, to make sure that everything is under control. Now, it would be unfair for an employee to vacate his employment and then only be told after 4 or 5 months down the line, when the MEC was perambulating on the matter, to say, now we have now decided all of a sudden he must go back, in circumstances where he can't even go back because now he's already ensconced in the position which he has assumed. So we submit that the 14-day period was not without a reason. That is why, in fact, the legislative reforms which appear from the bill makes this point very clear in the amendment bill which we circulated yesterday. That is exactly what was the intention all along, that we should have finality on this issue. So our submission is that on the 14-day rule, once the MEC did not act within the 14 days, he missed the boat. And the matter was transferred immediately to the hands of the minister, who too did nothing about the matter and missed the boat. I had the debate about whether the ministers is circumscribed to do anything within 14 days. I think so. If you read the Amendment Act itself, the old Amendment Act, it said as much. Well, it said the MEC had to act in accordance with the provisions of subsection 8. And acting in accordance with the provisions of subsection 8 constrained the minister to act within the 14-day period as well. That's our submission. So the minister too did not have a laissez-faire, an open hand to wait for 5 months, as it were. In fact, that reading is necessitated by another reading of a clause in the Amendment Act, which is subsection 7B. Because you recall that in terms of that act, when the municipality proposed to appoint a municipal manager, they will send a report to the MEC, and immediately upon receipt, the MEC too must submit that report to the minister, so that the minister can also start exercising his mind. That is why there is a double-barrel reason why these things, these timelines were put, to constrain both the MEC and the minister to start acting on the proposed amendment before it takes root. So in our submission, we say that there was a clear reason why the legislature inserted time frames within which certain things had to be done in relation to the challenging of the position of the appointment of the municipal manager, to protect the municipal manager and to allow for swift decision-making process to take place. In the terms that I think Justice Chapter did explain in the shower, that in the passage we quoted in our heads of argument, that in appointing municipal managers, there's always a sense of agency. You can't let matters lie.
Mr. Matonzela, your 10 minutes protection has expired.
I've actually, the two, thank you, the Chief Justice. I've actually dealt with the core arguments that we make in this case. The others relating to dispute of facts are there in the heads of argument. We say that, but the most important one, I think, is one of just an equitable remedy. I mean, even if we are wrong on all the points, just like the concurring minority of the SCA said, even if we are wrong on the point, what purpose does it serve today? And how just and equitable is it today? 5 years or 4 years down the line, when the municipal managers are left with only 3 months. In fact, just to correct, the municipal manager's contract of employment expires in December this year. Just to put that plain, not a year after elections, December this year. What purpose would it serve to now declare their appointment null and void? We say to not be just and equitable, to give effect to the law that once was, and the law which is now effectively a dead letter, and give it some life 5 years after or 4 years after it was buried by this court in the declaration in some matter. So now submission will say that this application should fail and the court should not entertain it and dismiss it with cause. Also, on cause, we say that the court should not make any orders to cause because it's government to government, and the applicants or the respondents here were the municipal managers were funded throughout by the municipalities. So those are our submissions in essence.
Mr. Maronsela, may I just take you to mootness? As I understand Mr. Dixon's argument, he says that when they launched the applications in the High Court, and when that court gave judgment, the period of suspension was still extant. So those, the municipal managers' applications and qualifications, had to be measured against the then extant Section 54A. And the SCA in the judgment of Mulamela JA seemed to agree with that. She says in paragraph 13 of the judgment at volume 4, page 327, paragraph 13, the learned judge says, at the time the court of quo heard the application, the suspension of the order of constitution and validity was still extant, which meant that the minimum requirements stipulated in Section 54A was still in force. And the summary judgment served as no obstacle to the hearing of the applications. And she also says later, it's not an impediment in relation to the hearing of this appeal, the fact that the suspension period has come and gone by the time the appeal was before the SCA. Now, that to me is a difficult approach to take, because where does that leave us today? I mean, even the SCA, where did it leave the SCA? Where you say they were entitled to rely on a section which no longer exists. Is that a proper approach to take?
I disagreed. I disagreed even the SCA. I disagree to now. If a matter does not serve for the court and is not dealt with by the court during the lifetime of the suspension in the order of invalidity, hard luck to the person. But if it takes over later, then of course we are dealing then with a statute that is no longer there. It must all depend on whether, I mean, it was open to the municipality if it wanted, or if it foresaw that the legislature was not going to save the declaration of invalidity by passing a law to salvage the legislation. to bring an application on an urgent basis for it to be dealt on an urgent basis, if there was something critical for the municipality to preserve or to insist on during the interregnum of the suspension of the invalidity order. So that was not done. It's the hazard of litigation that when you want something to be done on an urgent basis and you have a reason for it, you must bring the matter on an urgent basis. If it is heard after the invalidity and you do not insist on the urgency, you must fall where on the basis. The reality of the matter is that, sorry, just.
No, please finish, sorry.
The reality of the matter is that when the court, the SCA hit the matter, and even the High Court as well, was when it determined the issue, it was already towards the end of the lifetime, or even after the lifetime of the Amendment Act.
Well, the High Court gave judgment about 19 days before the expiry date. But the point Mr. Dixon makes is this: he says it's anomalous for a municipal manager to be disqualified in terms of that section while the suspension period inured, in other words, until the High Court gave judgment, and thereafter, when the section falls away, that disqualification no longer applies. What do you say about that argument?
No, I'm sorry, I don't know whether I understand the question, but if you bring an application and the court makes an order in relation to an order of invalidity, in order to preserve the last life of an act, and that life, that order, I would imagine, is based on the hope that the municipality is going to salvage the statute and then give it further life. But if the legislature drops the ball and does not salvage the legislation, the principle of objective constitutional invalidity takes effect, because then you go back to square one. It's the municipalities' fault, it's the MEC's or the government's fault in not salvaging the situation. So our submission is that it is not something that must redound against the respondents in this case. It must be a matter that must be placed at the doorstep of the government department, in MEC in this case, or the minister, who has not salvaged the legislation during its lifetime. Because if he had, we would have a difficulty.
Thank you.
Mr. Madanzala, can I ask for clarification on one issue? You submitted that the appointment of these municipal managers constituted administrative action to which PAJA applied, and because there was no application for condonation, the matter may be disposed of on the basis of that point alone. Now, I just would like to hear your submission on this. Isn't Khumalo, the decision of this court, standing in the way of that? In Khumalo, what happened there? The MEC specifically or explicitly in the notice of motion and the affidavit said that they were bringing the application in terms of PAJA. There again, there was no application for condonation, but the majority in this court said, well, the MEC could have brought the application under legality, and therefore the delay would be assessed in terms of what the law applies to legality. Wouldn't that be the same here? And if so, are you inviting us to reconsider Khumalo?
Well, I think since Khumalo was decided, the law has somewhat evolved and the principles have been refined to require, and I think as I read the judgments from the Constitutional Court, as I read them, there's a trend towards first excluding parja before you rely on legality. That's obviously informed by the principle of subsidiarity, that you can't rely directly on the Constitution where there is a statute that specifically provides for an administrative action review. So I would say that on that question, that Khumalo's approach on delay by approaching the matter from the prism of legality reflected the thinking at the time, which has been refined now, to say that if the court wants to adopt the legality approach, it must first exclude parja. So I would say you should refine Khumalo so that it reflects the jurisprudence of this court that seeks to exclude parja first before you rely on legality. And on that note, I would say that this court has already done so in, I think, Modau and other cases where you said, in these two pathways of review, the other one is a backstop, which is legality, but the frontal one is a parja. Well, if you find, you have to get into the discipline of saying, is it parja first? Once you exclude parja, then you can then fall back. But you can't just frontally attack a decision on basis of legality if it is parja without excluding parja. So Khumalo should be refined to reflect that the court will not be open, or our courts should not be open, to entertain delay questions under legality without excluding parja. And the approach in Khumalo should be refined to that extent.
Can I throw in a spanner?
Please, Justice.
In a later decision of this court in Gijima, we said that when public officials are seeking to review their decisions which were wrong, they can't invoke parja. They can only do so under legality. What do you say to that?
Yes, well, I was in this court last year where the same question was thrown at me. The problem is Gijima had certain qualifications. In the first paragraphs of the judgment in Gijima and Madlanga's judgment, he makes a qualification that the judgment is not before me.
I'm sorry, Madlanga J.
Justice Madlanga.
I'm so sorry, Justice Madlanga. When in that judgment, there is a qualification that made that this case, the Gijima case, should not be read to include other circumstances. And there's a footnote, actually, if I remember the judgment, that actually makes, we are now, what Justice Madlanga says, we are only dealing with a self-review and not an applicant bringing an application qua employer or some other, or private, in a private sense. The words to that effect. So Gijima was circumscribed, and it had that internal modifier to say it does not apply generally. And in fact, I think specifically Justice Madlanga left the question open for other cases to come, where in different circumstances, applicants bring the applications under self-review applications or other applications qua the government in circumstances where they are not really constrained by the Gijima principle. So I think that this is one of the cases which is not covered by Gijima, because Gijima was really concerned with a self-review. And this is not, in fact, a self-review. It's a review of one government department over another government department in different tiers of government.
No, but the ratio was parja was enacted to give effect to the rights in Section 33 of the Constitution. And those rights were not conferred on the state. They were conferred on private parties. And therefore, government, when it seeks to review decisions, cannot use PAJA as the pathway. That is the ratio in Gijima. So to me, sorry?
Sorry?
Yes, to me, it means then that if you are a government applicant seeking to review an administrative action, unless you can show that you enjoy the administrative justice rights entrenched in Section 33, you cannot use PAJA. You have to use legality.
Yeah, Justice, I think the ratio in Gijima was that when a government institution and organ of state brings a review of its own decision, PAJA is not it does not sit comfortably in that scenario, because PAJA would require them, for instance, to produce a record. And how would the mechanism of PAJA fit into an own review decision? In fact, the paragraph that I'm talking about is paragraph 2 of the judgment, which says we must emphasize that the issue has nothing to do with a scenario where an organ of state that is in a position akin to that of a private person, natural or juristic, may be seeking to review the decision of another organ of state. There is it. And we are really on that terrain that Madanga carved out of Gijima.
Okay. All right, so I heard you. Thank you.
I see Justice Madanga is smiling.
Yes, because once again, you referring to Justice Matlanga as you refer to him outside of court, Mr. Griffith.
Oh, I'm so sorry, Justice. I didn't notice. So, in all the circumstances, Acting Deputy Chief Justice, I asked that the application be dismissed first.
Thank you, Mr. Matonsela. Mr. Dixon, your reply.
Thank you, Acting Deputy Chief Justice. I just have 2 matters. The first thing is to correct, thank my learned friend for putting in the spotlights the term of the contract. In terms of section 57(6) of the Systems Act, the fixed term contract of a municipal manager is a maximum of 5 years, subject to a period not exceeding 1 year from the next election. So as far as the Nkandla case is concerned, the appointment was made on the 26th of January 2017. 5 years from there is 25th of January 2022. And as far as Ntonjaneni is concerned, 19th of December 2016, 5 years added to that is the 18th of December 2021. So he's right about the one, but not the other. And I was wrong about the year after the next election. It just seems to me that time has flown with this case. I didn't think we were in 5 years already. Anyway, that's the question of the fixed term. The second thing is that my learned friend has referred to Matau's case, Minister of Defense versus Matau, judgment of the Acting Deputy Chief Justice. And at the end of section 36, it says that it is not easy to make the distinction between executive and administrative action. The determination needs to be made on a case-by-case basis. There is no ready-made panacea or solve-all formula. And the debate between Justice Jafta and my learned friend illustrates that with the principle in Kajima's case. And perhaps if I could just mention this in relation to what happened here. First of all, it's a power given to the MEC, an organ of state. It involves the appointment of a different organ of state in relation to a municipal manager and in relation to it being null and void because qualifications were not met. And the MEC then is given the power in terms of section 54A to seek a declaratory order. Now those components, appointment that is null and void, in other words, there's no discretion being exercised by a decision maker, it's just objectively null and void. And then the MEC asking for a declaratory order that is in fact null and void. It's not a PAJA remedy with respect. It doesn't fit in to the terminology of PAJA or section 33 of the Constitution. And that is why I've always dealt with it in inverted commas as a legality review. In fact, it's not even a review, but it is a case brought on the basis of legality. So my submission remains then that this is not a PAJA case, it's a legality case, and whatever consequences flow from that. Thank you, Acting Deputy Chief Justice. That is my reply, unless there's anything else.
Thank you, Mr. Dixon. Judgment is reserved and the court is adjourned.
As the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.